Welcome to Engaging Country Conditions Experts in Asylum Cases, sponsored by the Commission on Immigration. To receive CLE credit, you must attend the entire program. Partial credit is not available. Please click on all participation verification alerts to confirm your attendance. After the program ends, a link to complete the certification process will appear. Please complete the evaluation and the CLE affidavit, providing your bar information as requested, and submit. Once your attendance is verified, your certificate will be emailed to you. Moderating the program today is Laura Egan. Laura is a managing attorney for pro bono and communication with the ABA's Children Immigration Law Academy. Laura, you may proceed with the program.
Thank you. I'd like to briefly introduce the rest of today's panel. Joining me on the program are Dr. Amelia Frank Vitale, Dr. Lauren Heidrink, Ellie Norton, and Ann Dutton. Amelia received her PhD in anthropology in 2021 from the University of Michigan and is currently a postdoctoral research associate and lecturer at Princeton University. Lauren is an associate professor of human development at California State University, Long Beach, and is a cultural anthropologist who focuses on childhood and migration in Central America. Ellie is a senior practitioner in residence in the Detention and Deportation Defense Initiative at Seton Hall University School of Law. Anne engages in strategic litigation on a range of asylum issues and provides technical assistance and training to other attorneys representing asylum seekers at the Center for Gender and Refugee Studies, CGRS, at the University of California Hastings College of Law. Please feel free to read our extensive bios online. Thank you so much for joining us. So we're going to turn to our panel discussion today, and I'd like to start off by asking the panel what successful strategies there are in matchmaking the attorney, the expert, and case. And so just to get us started on this topic, when do you use a country conditions expert? Lauren, Ann?
Sure. So I can jump in and offer some initial thoughts. I mean, basically, when thinking about using a country conditions expert, I think it's a good practice for attorneys to at least evaluate whether that's something you want to be doing in every case that you have. Um, of course, it's not realistic always to have a country conditions expert in every case, and we can talk about the factors that might, push you one way or the other. But I think things like timeline, cost, if you have very strong existing country conditions materials that really cover the issue that the client's claim is presenting, you might decide not to, or that it might not be possible to get an expert. But in general, I think, it can be a really critical tool for shoring up almost every element of an asylum claim, and is definitely worth considering in every case.
Great, thank you. And what are your thoughts? How do you find a country conditions expert? So you're working on a case and you need to find somebody to assist. How do you do that?
So, for a little bit of shameless self-promotion, the Center for Gender and Refugee Studies has an expert database that I would encourage everyone to look at as at least a starting point. It's a couple of years old, so we're still trying to grow and develop it. So not presenting it as the exhaustive resource on experts, but we are trying to make it easier for folks to find experts because we know it can be a tricky process. So on the CGRS website, there's a link to that, has country conditions experts, as well as medical and forensic psychological experts as well. Other than our database, which does not have resources for every conceivable type of claim, I found experts through listservs, asking for recommendations for folks who have worked on similar types of issues. You can talk to in-country contacts, looking at academic publications on your relevant topic, Google searches, things like that. And Lauren, I don't know if you have anything else you'd like to add to that.
Yeah, absolutely. And just I'm grateful for this space to be talking about these really important issues. And I really would encourage those scholars and academics on the call to get active in this work. I think in terms of identifying country conditions experts, there's a few different ways. So if you get a case as an attorney from a local nonprofit, right, they may have experts in other cases that they can direct you to. If you have in your firm a pro bono coordinator or other folks that are doing asylum interviews, an asylum representation, asking your colleagues, because they may have experts, they have personal experience, right? Working with experts, were they good? What kinds of work product did they develop? And so I think those kinds of networking is really important. I would say in terms of kind of reaching out to other academics or scholars, I do think listservs are really useful. So for example, the Latin American Studies Association has a working group on providing expert witness declarations and expert witness testimony. And so reaching out to those folks with a very short kind of description of the case that you're working on, knowing that that will get disseminated widely and forwarded. So making sure that that information is as limited but also specific as you need it to be. And then looking at academics who are doing empirical research. And so by that, you want to think about people who are in the country at the current time, right, or in the recent past. So those tend to be anthropologists, sociologists, geographers, people who are doing in ethnic studies departments. And so I think looking at publications is helpful, looking at faculty profiles are helpful. Reaching out to the American Anthropological Association, the American Association of Geographers, the American, or the, I think it's the Association for, American Sociological Association, the ASA, but those types of kind of overarching umbrella organizations, I think often have listservs. And then more specifically, so I work in Guatemala, there's a Guatemalan Scholars Network that you can find and you can ask them to post. And those often get picked up if you're looking for specific types of expertise. So those would be some of the places I would start.
Fantastic. Those are some great ideas. Thank you both. And since we're talking about matchmaking the attorney, the expert, and the case, how do you ensure that it's a good fit amongst all?
Yeah, I mean, so when I am considering whether to work with an expert, I think the threshold question for an attorney should probably be whether they will be able to be qualified as an expert in immigration court. And so, this is not like a substantive legal training, but just as a general reminder, the rules of evidence are not applicable in immigration court, but they can be helpful guidelines. And so usually I look at the standard laid out in Federal Rule of Evidence 702, which basically requires specialized knowledge, scientific, technical knowledge in the relevant area. So definitely that is a preliminary consideration. And I think one thing I do want to emphasize there is that obviously folks who work in academia have a range of things to offer an asylum case and have credentials that can often make it a very easy fit to be qualified as an expert. But that's not to say that folks who are non-academics can't serve as expert witnesses either. We definitely have worked with folks from nonprofits in country, others who are kind of on the ground doing the work certainly have developed that kind of specialized skill and knowledge as well. So look broadly and think kind of creatively about what specific pieces of your case you really are hoping that the expert can corroborate. I think, and on that, I mean, I think one helpful piece in starting to do outreach to experts is if you have your case developed to a point where you can be as specific as possible about what type of content you're looking for in the declaration. That is, I think, helpful, but I would turn it over to Lauren to talk also about what's helpful from the expert point of view to receive in that initial communication.
Yeah, I mean, I think from my position, part of kind of the initial steps are having a conversation, right, and learning about the argument and learning about the case history and the facts. I tend to only work on cases where I have done work in the region, right? So some folks will do work in Guatemala and will write a declaration about, the country conditions, having never been in the region where the person is from. So that's a personal choice that I've made of I feel more comfortable and more confident on the stand saying, no, I've been to this region. I've worked there for 10 years, right? And having that expertise and that research to draw upon. But that's not necessarily right the threshold. And so I think, again, making sure that you have an expert who can speak to the fact pattern. I do decline cases, and I think being really candid and open in that conversation to ensure that it's a good fit. So if the fact pattern that's presented doesn't line up with my experience or the research. That doesn't mean it's not true, right, that the person is putting forth their own case, but I, in court, might not be able to speak to that fact pattern as substantiated in the research and in my experience. Or there may be arguments that the attorneys are making that I can't support with the research that I've done, right? So being really candid of saying, this may be an inconvenient analysis to the arguments of your case, and I want to be forthcoming about what I can say and what I can't say. And if I'm on the stand, this is what I'm going to testify, and ultimately you need to decide if that fits, right? If that's going to be a hindrance to your case. I also think just thinking really practically about timelines. Most of us do this on the side, right? We have full-time jobs, we're teaching, we're doing our own research. This isn't something that our institutions quote unquote value. And so many of us are just doing it because we feel compelled for any number of reasons. So I think I often weigh, how many cases am I working on? Do I have time in my schedule? Am I available the day in court, right? Sometimes if I'm traveling abroad and I won't have reliable internet or phone access, and that will just kind of take it off the table. So I think the other thing too is when you get to the point, and I know Amelia and Ellie will talk more about it, but having a copy of the declaration and being able to review it and see if I feel like I'm a good fit for this. And I'll be very candid if I don't think that I am. And I think from the attorney's perspective, asking, have you been qualified as an expert in immigration court on gender-based violence, on gang violence, on child abuse, whatever it is that the basis of the case is? And if I have, and I've done 30 cases and been qualified as an expert in gender-based violence in Guatemala, that's going to be a much more compelling declaration and testimony in court. So I think asking the expert, have you ever worked on this type of case, and have you been qualified as an expert, is a really good starting point.
And I would add to that, Lauren, I think the kind of the corollary piece of that question too is then asking about specific challenges that the expert has ever drawn, if they have had bias allegations or other things come up, which is kind of part of that same inquiry, can be helpful to, and it's certainly not a reason to not proceed with that expert, but just let you know kind of going in what type of issues you might need to be preparing for.
Thank you. It's very helpful to hear from both perspectives, the attorney and the expert. So, just to elaborate on those issues a little bit more, what do you think really needs to be nailed down at the beginning of the working relationship to just for it to work well?
I think so. I can start and then pass it to Lauren. I think from my end as an attorney, what I'm usually thinking about is certainly cost, like having that be very transparent from the beginning is important. I think also, as we've gotten into this kind of world where, at least for a lot of defensive cases are continually getting kicked, it's been very helpful for me to have very concrete guidance on kind of splitting up the cost for different parts. So making clear, like, okay, this is the cost for a written declaration, this is hourly rate for testimony prep, this is an hourly rate for, holding time to appear at the hearing, so that if the hearing is kicked and you have a declaration but there hasn't been testimony and it's 4 years down the line, you can start to talk more concretely about how you could compensate for the work that's already been done, and have that just be clear. Timelines, certainly for drafts, for testimony prep, making sure that all works with the expert's schedule and works in a way that works for the case development. Another thing that I always try to be pretty clear on is the anticipated depth of revisions. So I know that I'm a pretty hands-on reviewer, and different attorneys have different practices on that. And I think Lauren can speak to different experts' practices on this as well. But I do a very close review and will offer comments. And so making sure that the expert is kind of comfortable with that up front and understands that that's my preferred way of working. But would love to hear what Lauren thinks from the expert perspective.
Yeah, I mean, I think it probably goes without saying that academics are a very special type of people. And so we vary considerably. So I love the feedback. I love the hands-on. I love the, giving me comments, asking for additional information. And it really helps me to clarify for the judge, right, who may be asking these same questions. but experts really vary, right? Some are like, this is a declaration I have. I'm not going to tailor it to the specifics of the case. If you're paying for it, this is what you get. And so I think even asking those questions about how tailored will the declaration be, right? It's not just a country conditions report, right? It's tied to the facts of the case that you're presenting. So I think having a very candid conversation about kind of their preferred style of work and feedback. The same goes for testimony prep. I have been doing this for a very, very long time, but I always want testimony prep. I want to learn the nuances of the case and the style of the attorney. Oftentimes we prepare, right, to testify, and we actually only present a very limited amount of, or a limited kind of scope of the testimony, but I think running through it a few times. And so I think asking that question, like, are you willing to be prepared? Some experts that I know of, right, refuse. I've been doing this for a long time. Like, just put me on the stand and it's fine. I think also asking about their experience testifying telephonically or on WebEx versus in person. I think particularly during COVID, if you have folks that haven't been doing this work or have been doing this work kind of in the period of COVID, all we know is telephonic, right, or WebEx often for detained cases. And so if the courts do open up, right, and you are presenting in person, that's a very different type of testimony and practice. And so I think just being clear about that. The other thing I think, just in terms of, and we may get into it more, but in terms of payment, I mean, I think that there's a lot of discussion, right, among folks that do this work, right, whether we should be compensated or not. Some feel that, doing it pro bono is a service, and applying our research. Others feel that, we should be compensated for our labor and our expertise. So I know that a lot of people have different approaches. And I think, having that conversation, I do a mix of both, right? Paid if there are funds available, pro bono, and make sure that the client is never charged a dime for the work that they're doing with me. That's kind of my line in the sand. But having those types of conversations are important. And I really value, what Anne was saying in terms of breaking it into pieces, because these cases do go on for quite some time. And so if you are expecting the expert to revise, making sure that that's clear in your letter of engagement.
Thank you. And specifically, how would you manage getting an expert statement to support an affirmative asylum case, for example, when you don't know the particular date of the client's interview is a little bit less certain, perhaps?
Yeah, I can say, so I don't work on affirmative asylum cases, just for total transparency, but I think some of the issues are kind of similar to what we've seen in defensive cases, where cases just get continually bumped at the last minute and you kind of have a lot of uncertainty. And so I think, if you decide that an expert would be helpful for an affirmative case, I think that one thing you could consider would be having an expert kind of prepare a declaration, have it ready to go, but not finalized and not submitted until you have your interview date. That would, of course, then require the expert to be willing to kind of hang around for an unspecified amount of time, and be willing to do that kind of refresh work if any is necessary before it would be submitted. But that might be one way to, have content developed but not finalized until the hearing comes close. Yeah, Lauren, any thoughts?
Yeah, I mean, just to chime in, I mean, typically, so historically, I have done more affirmative cases, but I think as resources become less and less to do this type of work, I think attorneys often don't get appointed until, or don't get assigned until the merits case. And so the affirmative cases I've done have been people that I know, right? People that have reached out to me from Guatemala, or, on behalf of family members, or end up here. And so I'll provide declarations in those cases. But in terms of, I do think the information can get stale. And so making sure that, again, you have that conversation with the expert. Unfortunately, change is really slow where I work, right, in Guatemala, and I would say Central America, right? These deeply historical and structural inequities, right, have existed since colonialism, right, obviously, and I think do shift. But I think where updates are helpful, right, is if the State Department, I mean, in the cases that I work in, much of the work falls under a particular kind of I forget what the English, the particular ministry. And the US State Department, for example, has issued a number of warnings that the director of this ministry is deeply corrupt, right? And she and her husband are no longer allowed to travel to the US. And so those types of developments are really helpful, even if it's not a matter of the information going stale, but a new development. And so I think either updating the declaration or doing an addendum to the declaration that the expert does can be really useful to show that the facts on the ground either have not changed or have changed for the worse in those cases. So I think that probably applies for both affirmative and non-affirmative. And I don't know if Ellie or Amelia, if you want to chime in as well in terms of affirmative cases.
I only have just very little experience in that. I tried to assist someone who I knew from Honduras. I work in Honduras. With an affirmative case, and the attorney that he had, she didn't really know what to do with an expert, because I think they just have such a different framing for how they put together cases. And he won his case without expert testimony. She had all the country conditions under the sort of particular processes that she's used to using, and didn't really have space or need for me in the way that defensive cases do.
It sounds like it might just depend per case and be a consideration depending on the facts, and maybe something to consider for a universal declaration as well, to see if that is a good fit in that scenario. Thank you for all those perspectives. So kind of turning to our next issue, just in terms of successful strategies in preparing cases together between the expert and attorney. And Amelia and Ellie, maybe y'all could start us off just in terms of what are some of those best practices when working together on a case.
Yeah, I mean, I think Anna and Lauren touched on a lot of them. Just to me, the most important thing is clear communication and making your expectations known upfront from the very start of the case. Just not assuming anything about what the expert knows, what the expert's practices are, or how the relationship is going to play out. So some of those things like payment, like how many times you expect to review the expert's report. I just try to put all of those things in the retainer agreement in writing, and just have those conversations with the expert as much as possible upfront. Amelia, what do you think on that point?
Yeah, I would agree. I think really clear communication is essential. As Lauren mentioned, there's a lot of debate within sort of our circles about whether and how much we ought to get compensated for the work that we do. And so when attorneys do reach out to us, I think it's really helpful to have that laid out, what their expectations are. If they are asking for pro bono work, to make that really clear and to not leave it up to the person you're contacting to raise the question, because there's such a variety of what is considered normal. And I think among attorneys and different law firms, it's also, there's just such a wide variety. And so, especially for experts who are kind of new to this, people don't really know what is standard, what is appropriate, what's within the realm. I also have a similar policy for myself as Lauren, where I don't take fees from the client, but I'm very happy when a law firm has the capacity. It really does help. So yeah, I think just laying out as much of that initially as possible is really, really helpful.
And maybe y'all could speak to, what you need to have prepared in advance before you initiate these conversations. What conversations with your client might be necessary, and what information should you be ready to give the expert in advance?
So I always try to do as much factual investigation into the case as possible. I mean, that goes into the decision about whether we need an expert in the first place. I try to the extent possible to have a declaration from my client ready, but I do work almost entirely in the detained context where the case line timelines are very truncated. So sometimes, particularly when it's a particularly complicated case, it's just not feasible. Or there are issues with setting up confidential communications with my client. It's just not feasible to have a 100% finalized declaration. In those cases, I will at least try to provide a very detailed summary of the case. And one thing I will always do is provide a list of issues that I want the expert to address in their declaration. And then also, if there are any sort of ancillary documents or evidence that I think are relevant to the expert, declarations from family members in the country of origin, police reports from the country of origin, anything that the expert might get asked if they reviewed because it's clearly relevant to the case, then I want to make sure that they have those documents as soon as possible.
I will say from our end, getting some really specific geographical information right away is really useful, down to the neighborhood level, like not just the region or the town or the city, but the down to the neighborhood can make a world of difference. And then knowing who the actors are. In my case, I mostly do gang related cases. And so knowing whether we're talking about gangs or narcos or which gang, initially really helps me gauge how much work is going to be needed on my behalf, whether or not I have really specific information already or would need to figure it out. All of that, those details, less so than the actual personal details, but the details of who the people are persecuting the person, and the geographic details are really helpful to have right away.
Yeah, and I think that that's the kind of information that, if as long as I have that who, what, when, where, I would feel comfortable reaching out to the expert and generally err on the side of reaching out as early as possible to give the expert enough time to prepare a report because often I only have a month or 6 weeks before our individual hearing. So as long as I have that key information, I'll contact the expert so they can get started.
We kind of heard from Lauren and Anne on this, but I don't know if you want to offer any viewpoints as well in terms of whether or not the attorney or advocate reviews a statement and how that interplay goes, just practically speaking, for the advocate.
Yeah, I mean, I always review the statement, and I will put in the retainer agreement that I plan to review it at least once, and may ask to review an additional time if that's reasonable and necessary. Um, and yeah, in terms of how I will review it, I tend to not do track changes or redlining in the report, just because I think it's very important that all of the experts' words are their own and all of the choices that they're making are their informed choices. So I tend to leave comment bubbles with any suggestions or questions or comments that I have, and then if necessary, maybe set up a phone call to talk about any big picture issues that have come. Is that consistent with your experience, Amelia?
Yeah, I'm very happy to have the framing and the structure of the affidavit changed and edited by the attorneys I'm working with. When it's stuff about the content and the kind of argument that's being made, having a conversation or raising a question, I do appreciate more than the attorneys making those changes directly, because sometimes the language that we use is intentional. And although it might be legally expedient to use different language, there might be reasons that we don't. So sometimes it's not. Sometimes the attorney changes the phrasing and I'm like, oh yeah, that's actually much better. And sometimes I'm like, oh, actually that changes the meaning in a way that is not consistent with my knowledge of the country. So those kinds of things, it's really helpful. But like, I've had attorneys who have not wanted me to comment on the case until the conclusions of my affidavit, but to keep everything else very fact based. And I've had other attorneys who really wanted me to, at the end of each section, have a paragraph or two that links that section to the facts of the case. I've had attorneys who have wanted me to have not a concluding section, but a different kind of summary section, or who have wanted more data on police or less data on police. And those kinds of things, I want to do what is best for the legal strategy. And so I'm really happy to have them, move things around or delete entire sections that they think are irrelevant, because that's what these affidavits are for. They're not for, my writing projects.
Thank you. Very helpful. And then also, what information does the attorney provide just on the basics of asylum law and eligibility requirements, if any, to the expert?
I think it depends on the expert and sort of how much experience they have, and this is something that probably come up in an initial conversation. I think to the extent that if the expert is quite experienced, then I will usually just go over what our legal strategy is in this case, and make sure they know what the primary issues are, and have a good sense of what we expect them to address. I did work with someone who recently who had never been an expert before, and so then felt like it was a good idea to explain sort of more of the fundamentals of asylum law. And just generally, I try to be as open as possible and encourage experts to ask me questions if they're uncertain about our strategy, if they want to know more, or just want to ensure that their report is as accurate as possible. Then try to make myself available for those kinds of questions.
I would say it's really it, especially when we're just starting out. So I did my first case about 4 years ago, and it was a pretty quick turnaround. I was still a graduate student. I was in the field, in the middle of doing field work, but someone handed off a case that she couldn't take to me. And the attorneys, I see there's also a question in the Q&A that this is related to. The attorneys really held my hand. They really helped me understand what they needed from me. They less about explaining the intricacies of asylum law, but more about really what exactly my role was, what they needed me to be able to explain in terms of how the violence in the country was working and how the state was or was not able to manage that violence. But they even suggested sources to me that experts often use, things that I didn't know about, things that reports and databases that were not part of my anthropological training. And that was really helpful as a first time expert to understand how I fit into their broader strategy, which was up to them. I think it was very possible I would not have gotten qualified as an expert if I didn't have such good training from the attorneys that first time to really understand exactly what my scope was.
And I would just add too, I mean, there's a number of resources that are available online that, Amelia and I have been a part of training anthropologists, training folks in Central America to do this type of work. And so you can reach out to us, and we're happy to send you those links of video trainings just to try to, in some ways convince academics that they're qualified to do this work. Many of us are definitely qualified to do this work, but haven't been engaged, right, or been reluctant to think, oh, well, I'm not really an expert on this. But I think once you start to do the work, you recognize, okay, yes, I actually do have a valuable role to play in this process. And so I think looking at those trainings, I think if you have redacted samples, even from other countries, to get a sense of the form. I mean, I want to plug again, CGRS, they have universal declarations that are not obviously tied to specific cases, but are about specific conditions or phenomena on the ground. And so looking at those for some of the language and some of the sources can be quite useful to experts as they begin the work, and as you accompany them in this process.
Thank you all. These are some really great tips just for an advocate who's working with somebody who might be serving as an expert for the first time, and just how to make them feel more comfortable And, it seems like it does make a pretty big difference in terms of the working relationship too, just in terms of the expert's level of experience. And so maybe just gauging that from the beginning and seeing what additional information or assistance is needed. So, turning over to perhaps when working on a different type of case, maybe a child's case, is the process any different for working with an expert when preparing for a child's case?
I mean, so I work on a lot of cases of young people who have been detained in U.S. detention facilities for unaccompanied children. And so in many of those cases, it's not, they've been detained for a while, and it's not until they're released to a sponsor or family member that we start to engage with them in their work. I think with young people, it can be challenging depending on their age and their knowledge or their awareness of what's going on in the communities. So they may know, right, these are the gangs, but then asking questions, well, how do you know it's a gang, right? What marks them as a gang different from, a different gang or a different, group. So needing to ask much more specific questions. And I think as an expert, I think engaging an expert in types of cases where the facts may be limited, or the framing or the kind of other social and political phenomenon going on that an individual child may not be aware of, is a way in which you can engage an expert to fill in those gaps. And so, we'll talk about it in a little bit about talking to asylum applicants. I tend to not speak with young people directly. I think it can be confusing about who all these different people are. And so it's really relies upon the attorney to elicit information in culturally and linguistically appropriate ways. And so I think having an attorney who's trained in that type of cross-cultural communication, trauma-informed interviewing, right, can elicit more facts and more context that might not be readily available, at first glance. But I think as an expert, even being able to pick up, I mean, like Amelia mentioned, right, knowing what zone of the town they're from can help me situate their experience to, okay, well, this zone belongs to this gang in this period of time, right? And so what they say is a gang is likely, this particular gang or this particular group, because we know the context and we've worked in the area. So I think that you may be able to get the information from a young person themselves or from family members, right, or other people in their lives to fill in those gaps. But then as an expert, we can put it into that kind of sociopolitical context.
Fantastic. I don't know if there's any other thoughts on that particular question. Do you know, just from Sela's perspective, I think there's potentially, if you're trying to reduce maybe the child's testimony, so that they're not having to speak so much, either during an interview or during a hearing, then it might be even more important in that situation to get an expert's statement or have an expert testify, so you're able to rely on others' testimony instead. And it can also be something if you're not able to find, maybe your strategy relates to the individual being a child, and it might be more difficult sometimes to find country conditions reports that speak to those issues in a child-centric way. And so maybe you need an expert statement to really fine-tune those details and explain the information and how that relates to children specifically. And so that might be another reason why it might be even more important to get an expert statement or have an expert testify in a child's case. What about for other types of cases, maybe detained cases or expedited petitions? Are there any differences or reasons why it may be even more important to work with an expert in those situations? Or would the process be any different?
I think just sort of going back to, for detained cases, going back to what I've said before, just being very clear about the fact that these are very fast moving cases. And I think some experts who tend to work on non-detained cases think, oh, well, this maybe the individual hearing is sometime next year. We'll have many months to work on this case together. And I think just being clear up front that it's going to move very quickly and it's not likely to be rescheduled is really important.
I would just add, as the expert, knowing the conditions of the person, like if we ask for a continuance and the person is out and has a work permit, then like continuing the case for a year and a half is probably not a bad thing. It's probably not a bad strategy. But if the person is detained, continuance might be really hard on them, or even induce people to sign voluntary deportation orders sometimes, right? And so the the our impulse to maybe try and stretch it out or get more time or change the deadline, I think is really different if we're dealing with a detained case or a non-detained.
I think too, I mean, we're not talking about it too much here, but we do have country conditions experts. I've prepared declarations for federal cases, right?
Mhm.
Or in cases where children are seeking special immigrant juvenile status and the judge has a particular question or concern in kind of evaluating if a child's been abused, abandoned, or neglected. And so there are different ways that experts can weigh in. I know we're talking mostly about asylum at this stage, but if you do have are representing a client who's moving through these different systems, I think your use of experts may be different. You might be able to use the same expert for asylum, but also for a criminal proceeding or an SIJ case. So I think just to kind of think about why and how you're using the expert, and that some experts may be exposed to different types of different legal systems and not necessarily immigration.
And then kind of moving forward in terms of our next issue, in terms of experts talking to asylum applicants, I mean, is that common in your practice? Do country conditions experts generally speak with a client?
So it really varies. So I, for example, don't typically talk to the client directly. I'm really concerned about re-traumatizing an individual by asking them questions about some of the most difficult experiences they've endured. And so I think to the extent that the attorney has a trusting relationship with the individual, can understand the individual. I know sometimes there's attorneys that don't speak the language of the client, and it really is challenging. I think it's also the extent to which the attorney has experience working with individuals from that country. So there are some instances where I have spoken with clients, with applicants, and all these other facts come out, right? Because I've been in their community or I know what's going on, and it's talking to somebody who's familiar with that context. And so it can be really useful to have the expert talk to the individual. That said, not all experts are created equal, right? And so if you have an expert who is not trained in trauma-informed interviewing, or it is not sensitive to traumas and experiences, it can complicate things quite a bit and can be a really re-traumatizing experience. So I think it really depends on both the expert and also the attorney, right, and their comfort level of getting that information. And again, your kind of cross-cultural communication. So I think it really depends. That said, I know that there are folks who always talk to the applicant and always is kind of evaluating and learning more about their case. So maybe Amelia, you can chime in because I know you do some of that work.
Yeah, when I have an initial conversation with an attorney, I offer to have a conversation with the respondent if the attorney wants me to, always with the attorney present. I don't try and have a relationship outside of that because I don't think that's beneficial for anyone's case. I have found that frequently, especially I do a lot of pro bono cases for big law firms um, who their specialty is something other than asylum, and they take on these cases as part of their pro bono profile. And they often don't speak the language and often don't have much familiarity or background in the country of the person that they're representing. And so frequently, I find that by having a conversation with the person myself, there are details that emerge. There are phrases that I understand and interpret in a way that someone who is not as familiar with my specific part of the world would not. I will say, to just add to what Lauren mentioned, that part of what is useful about that is that I have been in Honduras very recently. I am there on the ground pretty frequently. I go back. And I was doing very similar work, talking to people about very similar things in context. And I think it's important that lawyers know that experts, we might come from a whole variety of disciplines, right? Political scientists typically are thinking about macro level patterns. They provide very useful data, but it is not necessarily the same kind of interviewing and training that someone like myself or Lauren might bring to these cases. So they might be excellent experts, but might not necessarily have the local micro familiarity to have a productive conversation in the same way. Then the only other thing I'll add to that is that I've actually been part of cases where both the TA and the judge objected to qualifying me as an expert before I was there to testify. So this all happened before I was in the courtroom virtually. They had some questions about it because I had not met with the respondent. And so I did meet with the respondent before the hearing happened. But they seemed to want me to be an expert on the person's credibility in general, which I don't think is actually our role. But I think that the blurred lines there sometimes are what they are anyway, even if that's not technically what I think I'm supposed to be testifying to. And in that case, meeting with the respondent was useful in general, and I think was helpful. But judges sometimes do take our testimony with less weight if we have not had a conversation with the respondent.
And I think to follow up on that point, I would just say too, like, going back to the kind of admission standards for evidence, federal rules obviously don't require that an expert have spoken with the client. They allow experts to offer expert testimony on facts that they have been made aware of. And I think, so you can, if you have a case where you've decided it's not the right move to have the expert speak to the client, certainly be ready to push back against any type of diminished weight because of that. And you can also point out, again, looking at the federal rules, there is the provision about how the expert can look at, sources reasonably relied on in the field. So you can talk to your expert, in a sociological context. Is it normal to be reviewing written testimonies and kind of like looking at that as a primary source and emphasize those types of arguments to push back against that?
And I will just add to that I feel like a situation like that ends up being really useful for an expert who is experienced, because whatever doubts the judge or the TA raises is an opportunity for me to fully explain something about how things work. So in my case, it's Honduras, and in this case, the TA raised doubts about whether or not I could reasonably take as true that it was in fact MS-13 who murdered the family members. And that opened up the opportunity for me to explain how nothing is ever really proven for sure in Honduras because of the lack of investigatory capacity, because of the rates of impunity, et cetera, et cetera. It allowed me to understand what potential doubt they were trying to sow and explain it better than I ever would have if they hadn't raised it in that way. So for an experienced expert, I think questions like that can actually end up being very useful.
It provides a lot of information and practical tips, so thank you all very much. So turning now to testimony preparation and testimony tips. Do country condition experts always testify and provide a written statement, or does that differ per case or potentially per expert? And what factors are you considering when making that decision?
So I always hope that the expert will be able to testify in the case. As Amelia was saying, it's a great way for them to address issues that the judge or the TA may have. And often, to be honest, the judges don't always read their written statements. And so I think it can just make a huge difference to actually hear from the experts. Unfortunately, I would say it's, in my experience, fairly rare for the expert to be able to testify, or particularly to be able to give full testimony. So often the TA will say that they're happy to stipulate to the experts that the expert would testify consistently with their written report. The judge doesn't have time or doesn't want to spend time on testimony and says, well, if they're not going to say anything that's different than what's in their written report, then we don't need this testimony. I always still push to have the expert testify. And one hook that I've found sometimes is that if the country is one where the conditions are constantly changing, Haiti has been a good example of this recently, where even though the expert submitted their report a couple of weeks before, there were important developments that I thought that the judge should hear about from the expert, and then that's a good hook to bring them in and at least allow them to testify as to some key issues in the case. I've also seen sometimes the judges allowing the TAs just to do cross-examination and then leaving a wide berth for redirect for respondent's attorney, which actually I usually push back against, because I don't think that that's how the procedure is meant to work. But sometimes it actually hasn't been a bad way to do things, because it does allow the experts to get straight to the issues that the TA and often the judge are concerned about. And then as long as you as the attorney are very clear and persistent on following up and ensuring that all of the relevant evidence that you want to get in the record on redirect is put in the record. It sometimes isn't the worst way to present testimony. At least it's better than not being able to, the expert not being able to testify at all.
Yeah, I would concur. When I first started doing this, I thought it was a win when the TA stipulated to my report and I didn't have to testify. I thought that was the best scenario. But over time, I've definitely come to feel that the opposite is true, that having the opportunity to be cross-examined is actually the best thing that can happen for the respondent, because it does give us the opportunity to answer their, I think, unanticipated questions, or the areas that they think are going to be the things that don't make sense. And pretty often, I think we can explain why they do make sense. But I do think that testimony for especially people who are new at this is pretty nerve-wracking. It's a scary, it's a weird, for academics, it's a weird scenario for us. I think if we're just starting out, it's a very uncomfortable situation. So doing prep, I think, is really, really helpful. And insisting on doing prep, I think, is helpful. Now, at this point, I often prep for the benefit of the attorney, because I feel pretty comfortable. But I think having that played out ahead of time is really, really useful.
And I would think too, particularly for new folks, and I think going back to one of the questions, and we encourage you to put more questions in the chat if you have them. But one of the questions was how do you make an expert feel comfortable, right? And so I think that preparation is helpful. I think anticipating, right, that the TA saying, well, you posted something on social media, or you wrote something about this, right? And trying to, have some sort of zinger, right, to discredit you or to depict you as an activist instead of an academic. I think practicing those types of questions, like why are you being compensated? Why are you not being compensated? Right? All sorts of answers to those initial questions are super helpful. And I think also framing it as, look, you're here to educate the court, right? We're educators. And so I think if I, as an expert, can step back and say, oh, well, they're not understanding what it's like on the ground, or they're making this assumption. How can I dispel this myth, right? How can I explain this in a way to my students, right? So that they understand the context. And so I think we're more comfortable with that role. And I think kind of, for me, it's been helpful to think about kind of being an educator of the court, a resource to the court to educate them on what's going on in the country, can help to lessen my own anxiety about the stakes, right, of the testimony and of the case.
I will also
Thank you
just
so much.
add that oh, sorry.
Go for
Oh
it.
no, go ahead.
Just that one of the first attorneys that I work with said to me, just remember, you know more about the country than anyone else in that court, with the exception of the person seeking asylum, of course. But you know more about the country than anyone else in that court. The judge, the attorney, this being the client's attorney, saying, we don't. That's what you're there for, to educate everyone. And for me, that was really helpful to be reminded that that we come in that role.
Yeah, and I was just going to jump from an attorney's perspective. One thing, I like to practice the direct examination, but also, as Lauren was saying, the cross-examination, and I kind of collect the most challenging and sometimes the most off-the-wall questions that my experts are asked, so that I can then practice those questions with other experts. And I say, you may not get asked any of these questions, but it's good just to prepare for the worst, and hopefully, the practice will be worse than the actual experience.
Thank you. And we do have a question that came up. And so this individual is working with an expert that's going to be testifying telephonically. That was part of their arrangement. But the question is, how do I prepare an expert for telephonic testimony? And how do I ensure that an immigration judge also allows the testimony to be telephonic?
So I can jump in and start on this one and just note that in my experience, a number of judges are treating WebEx appearances as the equivalent of in-person appearances, and so are not requiring separate motions for telephonic testimony for an expert who's willing to appear by video. And so I would encourage you to, call the judge's clerk and check if the judge that you're before is following that policy, because that makes it even more simple. In terms of preparing for telephonic testimony, I have honestly only had experts testify telephonically or virtually and have not had in person. So I think it kind of follows the exact same process. Running through the voir dire questions, running through the substance, and just kind of talking through some of the pragmatics about a remote appearance. So, tech concerns, making sure that you have a backup number to reach them at if something goes wrong, things like that. But from my experience, the preparation process is pretty equivalent to, I think, what an in-person testimony prep would be like.
I completely agree, and would just add, to the extent you can practice in the same way that the expert is going to be testifying, so on the actual phone that they'll be using, or by a video call, so that you can make sure that all of the conditions are right for the day, then that's a good idea as well.
And our next question is, could you provide some examples, maybe out of the ordinary questions asked of the expert, and maybe some surprise questions that have come up?
I mean, a couple off the bat are TAs looking at my social media, my Twitter account, and seeing if I ever retweeted something or liked something and what I meant by that. And I've had others, in my experience, there's not a lot of prep that goes into trying to find those questions. And so, for example, one TA just looked at my CV and said, will you talk about legal violence? Right, so I was talking about legal violence in the asylum proceedings, and saying, you're doing advocacy, and how is this even violent? And so again, I think just kind of putting my hat on as an educator, like, look, this is a sociological, term that's come up, that is developed 20 years ago, right? This is what it means, to really try to deflate the accusation. Or, you're doing it pro bono, so you must be an activist, or you're doing it paid, so you must be biased. I think just having experts be prepared for those types of questions. And so I have some kind of standard responses I give about, what I've benefited from public education my whole life. I have received all my funding to do research has been US, tax dollars. And so I feel a responsibility as a public scholar to do this type of work and apply my learning to practice. So I think that there are different types of questions that have come up, but just having that kind of response prepared.
Yeah, I think
Maybe
anticipating.
Go ahead. Sorry, Amelia.
Just anticipating the questions that they might ask you in terms of your qualifications. I've published some articles, like analytical articles about asylum as a system, as the system of international protection. And in a recent case, they brought that up, that maybe I didn't believe in the system, and having a response prepared for how like my theoretical work is different from offering conditions on the country in court. And before I got my doctorate, they tried to disqualify me all the time, which having a doctorate is not a requirement for being an expert, but they did try. So sometimes I had to educate the court on the process for getting a PhD as well, which was bizarre. But um, I think one of the, just a different vein of question where a judge thinks they know the country and they think they know what we're talking about, because they've read some news reports. And so I had a judge sort of challenge me on my characterization of gangs in Honduras, of MS-13, for example, and not taking that personally and just using the time to explain the nuance, or a judge suggesting that everything in Honduras was fine because the government changed hands, and also then having really up-to-date information at the ready to be able to explain why a change in politics doesn't actually change the underlying conditions so far.
Fantastic. Well, I do want to just make one last plug here. The ABA Commission on Immigration hosts a pro bono platform on their website, Pro Bono Matters for Families Facing Deportation, and CELA hosts a pro bono platform called Pro Bono Matters for Children Facing Deportation on our website. And our goal really is to match more pro bono attorneys with organizations' cases so that more families and youth have legal representation. So please check out those platforms and express interest in a case if you're able to. And that's all the time that we have today. But before we leave, I ask all attendees who want CLE credit to stay connected for instructions to get your CLE certificate. Also, please wait for the evaluation to come up on your screen. And to our faculty for this program, Amelia, Lauren, Ellie, and Anne, thank you so much for sharing your expertise with us. We really do appreciate it. And on behalf of the ABA, I'm Laura Egan, and thank you all for joining us today. I'm now going to turn it over to our operator for some additional information.
Thank you. On behalf of the American Bar Association and the ABA Commission on Immigration, thank you for participating in this program. To learn more about the sponsors, please visit the ABA web store at www.americanbar.com. Thank you, and please click on the evaluation link. We value your feedback.